Hey friends, come on in, type in freedom now. Type in freedom now. It is Monday, April 13th. We are just flying through this year. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in immigration freedom. If you're joining today on Instagram, welcome. TikTok, welcome. Facebook and McBean Immigration TV, welcome. Type in freedom now and say where you're joining from this afternoon. And if you're joining on TikTok, double tap the screen and give me some hearts. Okay, let's go with some hearts. And hello, 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 hello. And if you're joining on Instagram, also give me some engagement. Say freedom now and where you're joining from. Spring is finally here. We're expecting this week to be incredibly nice and warm. And I hope that you guys will experience great weather where you're located as well. We are reachable at McBean Law at 914-898-9488. We're located in White Plains, New York. For those of you who are new to us, we're located in White Plains, New York. However, we work virtually with clients outside of New York. So we cover all 50 states. And and globally, we have clients around the world who are facing various embassy problems, of course, coming to the United States and other issues and concerns that they have. So we do help individuals outside of the United States as well. Say hello, hello, hello. I see Massachusetts is in the house. Great to have you. I see someone from Berlin. Is that, is that Germany or is this Wisconsin? Berlin, Wisconsin. Where exactly are you? I see that Texas is in the house. Terrific. Again, friends, we're reachable at 914-898-9488. Someone is joining from Seattle. Thank you so much for the gifts on TikTok. It's good to see you. I see that Jamaica is in the house. Texas. Awesome. Thank you. Hey there, Eli. Good to see you. Helen, thank you. TikTok says you're a long time watcher. Thank you so much for watching on TikTok. A lot of Massachusetts folks are here. Sydney, Australia, Queens, New York. Wonderful. Thank you, guys. Thank you, thank you, thank you. And I know that our clients are on. I know that our plaintiffs are also on. Thank you so much for all of you who are here. Hey there, Angela from Maryland. Thank you for being here today with me. All right, guys, we're going to go right into some important news, I think. Each week I look at what's going on and I decide, I select, what I think is important to discuss during these, the time that we have together on Mondays. And there are three issues really that I want to address. And I'll start off with the first. The first one I think is incredibly important, and it has to do with a memo that USCIS issued on Friday, April 10th, called Special Immigrant Juvenile Classification. Oops, classification and deferred action. Friends, USCIS has been going under this administration, they've been going after youth or individuals who are applying for the special immigrant juvenile status. To allow them to get a work permit, get a social security card, and enroll in school, go to school, and ultimately get a green card. It's called the SIDGE process. And it's an opportunity that's available for individuals who are under a certain age, who go through a family court process and get and obtain an order by a judge, a family judge, which basically says that if they were to go back to their home country, they would suffer some real hardships there, of course, because they've been abandoned or neglected or abused, and that those terms are defined very broadly across the nation, across the state. But in any event, after they get this order, they then take it to immigration and apply for this special status. And during the time that during the time that they're waiting for the green card through this status. Our system allows them to get a work permit, enroll in school, and be defer and have deferred action, which means that we cannot deport them. Our country cannot deport them during this period of time while they're waiting for their green card to be approved. Now, this administration wants to pull really all of that when you think about it, but they're really trying to pull away the deferred action part and the work permit part. And this is going through the court system. It's being litigated. And as a result of the litigation, USCIS came out with this memo, and they're making four changes. First of all, they say here that USCIS will no longer automatically conduct deferred action determinations for SIDGE who cannot apply for adjustment of status solely because an immigrant visa is not immediately available. In other words, they're saying that we're not going to automatically stop a deportation process or removal process simply because the individual doesn't, because that individual is waiting on a green card due to the backlog in that category. We're not going to automatically do this for everyone, defer taking removal action against these individuals. Number two, deferred action. Number two, aliens with current deferred action based on their SIDGE classification will generally retain this deferred action as well as retain their work permit provided work permit that was provided based on their current grant of deferred action until the validity period expires. So if they've already granted you deferred action and you have a work permit, they're going to allow folks to hold on to their work permit and their deferred action until the end of that validity period. However, USCIS, within its discretion and on a case-by-case basis, may terminate deferred action through the issuance of a notice to appear or notice of termination and revoke any associated employment authorization prior to the end of the validity period. So they're saying that they still have the discretion to pick and choose individuals who they want to choose to end the deferred action and issue them a notice to appear in immigration court and revoke the work permit that they had received before the work permit and the deferred action period expires. Let's see. Prior to the end of the validity period. That's not great. And then lastly, it says here that aliens granted such classification may individually request deferred action like any other alien subject to removal in accordance with deferred action policy. So however, you can still seek this deferred action and they will make a decision based on a case by case basis. In any event, bad policy all around, and I think it's going to really hurt some people for sure, for sure. Secondly, guys, you might have heard that last week, the Trump administration announced the hiring of 15 immigration judges and 17 temporary immigration judges. And just a reminder for those of you who hadn't really been paying attention over the past year, the Department of Justice, they lost 100 or a little bit more than 100, I think, immigration judges because some of them, of course, retired. Others were fired. Others were kind of forced out, so to speak. And so it's been a very destabilizing system ever since this administration started. So they've hired these new judges. Many of them come from private practice. Some are former prosecutors. Many of them do not have immigration history or background or experiences. They have very random, I've marked it here on my paper, random non-immigration background. Like, for instance, they've worked at places like the New York Housing Authority, or they've done workers' compensation board matters. They've worked in the juvenile court system. They were city attorneys. Some had worked in the area of bankruptcy. Just a random pool of individuals here. Again, many of them do not even have immigration experience and background. So it's going to be interesting to see how they do their job. Okay. And then lastly, guys, I think this one is also important. You might say, well, this particular news is important for lawyers. Lawyers care about this stuff, but real people don't. I think real people need to care about this issue of the fact that the Department of Justice is pushing to basically protect and insulate their own cherry-picked individuals to work for them, attorneys who are working for the Department of Justice, to protect them from ethics and grievance complaints that are filed by us on the state bar level. The Department of Justice would like to, first of all, conduct its own internal investigation into the conduct of their own attorneys before these state bars are allowed to weigh in, which is quite ludicrous because, each of us, we got our license through a state bar. State bars have the ultimate authority over whether anyone gets to practice law in their jurisdiction, under, their jurisdiction, so to speak, and licensure. So Reuters reported last week that a coalition of Democratic state attorneys general urged the U.S. Department of Justice to abandon a proposal that would constrain state-level ethics investigations of federal prosecutors. The attorney generals laid out their opposition to a March 3rd proposal, saying it would allow the DOJ to insulate employees accused of professional misconduct and infringe on state sovereign power to discipline attorneys licensed in their jurisdictions. And the California Attorney General said that U.S. DOJ is attempting to place itself and its attorneys above the law. This is important for everyone to know about because, the Department of Justice is the law enforcement agency of the federal government. They're all working for us, really. They're working for us. And if they want to protect their attorneys from who commit misconduct, certainly that's going to trickle over into further abuses. There has to be a way for the states to weigh in on the conduct of these attorneys, and otherwise they're going to continue to erode due process and create havoc throughout our legal system. So this rule that the department proposed is a bad one, and the states are rising up to oppose this type of rule. Can you imagine? It's basically saying to their lawyers that they could do anything. And oh, by the way, there was a great exodus from the department because, it's very hard for ethical lawyers to operate under this new system. Let's go into your immigration questions today. All right, come on in. Freedom now, guys. Freedom now. And my moderator is also in the chat. Thank you for those of you who joined us on Friday. Last Friday, we had a terrific webinar with one of my colleagues from the firm. We had a great turnout. We talked about what to do if your case was denied by USCIS and you're in removal. We answered your questions. We kept our presentation very brief so that we had ample time to answer your questions. Guys, we have these webinars. So stay tuned for the updates about the webinars. Get into our system, subscribe to our newsletter at mcbeanlaw.com/subscribe so that you'll get updates about webinars and other stuff that we have going on here at McBean Law. All right, to schedule a private consultation with us, you'll need to call us at 914-898-9488 or go to mcbeanlaw.com. Okay, let's see. Let's go down to your questions. Thank you. Kenya is in the house. Ohio. Awesome. Wonderful, wonderful. Someone from White Plains, New York is here. Let's see. Go down. Okay. Thank you. Thank you, Stanton. Thank you. Will USCIS accept new DACA applications? So, we're all waiting for news from USCIS. Not just USCIS, actually, we're waiting for the judge in Texas to get back to the grind and wake up and do the work that the people demand and expect of the judge to do. We need action in that DACA case, and it's still sitting there from what I understand. And so new applications will be processed. The government had already said that that's what they wanted to do. They intended to process the new applicant, but they're waiting on the judge to weigh in on this issue. Any news about the pause, about the 75 country immigrant visa pause? No, I did check today with the State Department US Visa News website, and I haven't seen anything new about it. We're filing our lawsuit. We're aiming for today. So this live session will be kind of brief today, but we're filing ours today, and it's going to be filed in Washington, D.C. And those of you who are plaintiffs in that case will provide you with access to a plaintiff-only webpage that will track this litigation and other information from me and others from the firm. We will be sharing with our plaintiffs as we progress through that lawsuit. That's what we're doing for our 39-country lawsuit. If you are a plaintiff in the 39-country USCIS adjudication pause lawsuit, you might have gotten an email. You did. You absolutely did get that email today from me. Check your email. That said that tomorrow night we're going to have a meeting, a plaintiffs only meeting, but you must register for it and we will approve the registration. Only plaintiffs. Okay, so that's tomorrow night at 8:00 p.m. Eastern time, and that's the 39-country lawsuit, which is a big lawsuit. Okay, let's keep going. I have some important updates to share with you guys tomorrow. Okay, I've just joined. Not sure if you have mentioned it already. When is the next onboarding for the group lawsuit for the pause? So we are gearing up. We are gearing up to open up the round 2 by Wednesday of this week for a 39-country USCIS pause, adjudication pause. So we're going to announce it via email. If you're not on our email list, again, get on our email list at mcbeanlaw.com/subscribe. But yeah, we're going to launch that by Wednesday of this week, round 2. Round 2. Let's keep going. Okay, let's see. Someone says that his parents got denied in Mexico at the U.S. Embassy. They could reach out to us for a consultation so that we could find out what happened there and what type of visa were they applying for and see if there's a way to get them back on track. Any information about the I-290B? I've been waiting for 4 years. 4 years is an extraordinarily long time to be waiting on the I-290B decision. Again, reach out to us so that we could take a look at what's going on there. But it sounds like you're going to need you're going to need some real action. For us, when we see a case like this, the real action that we take for some people include things like maybe refiling a stronger case. It could also include filing a lawsuit, the mandamus, so that we could force the government to make the next move. How much is the lawsuit for the 39 countries? It's 1,500, 1,500, the same amount as the last one. Freedom Now. Oops. Is it, would it be better to let my dad enter with his B2 visa that expires soon and do adjustment of status or file for him while he's in Ghana looking at all that is going on? So, he is not allowed to use that B2 visa to enter the United States for the purposes of seeking adjustment of status. There, I've gotten that out. Now, if he comes here on that visa this summer to visit you and he decides that he's going to stay for whatever personal reasons he has at that time, well, fine. Then he could, he can do adjustment of status through the U.S. citizen son, I think there. If he chooses to, be in Ghana and stay in Ghana because he has a job or business and other important things going on there or family commitments, that's personal decision to be made. Yes, of course, as you can see right now, things are really crazy on the consular side of things, particularly for African countries. The policies are not great. Now, this last week, we talked about the fact that there's a quieter, very powerful movement happening behind the scenes with the administration to pause and shut down immigration from many different angles, many different sides, because their intent is, as they would say, their intent is really to have a moratorium on immigration from third world countries. You define third world the way you choose to define it. I think we all know what they're talking about here, right? So if you're from a country that this administration considers third world, well, more policies are coming. They are working on policies to try to shut some things down. So any opportunity you have to come to the United States for the summer and go to Disneyland or Disney World or New York, Times Square can be nice in the summertime. And, now might be a good time for that. Okay, let's go. Instagram, let's see. What questions do you have there today? Let's see. What questions do you guys have? Let's go down a little bit or maybe go up. Can we apply for a tourist visa while we're waiting on the immigrant process, the application at the National Visa Center? It's pending. You have a case pending. Immediate relative is what you say here at the Visa Center. I don't think that's such a great idea at this time. When we meet, if we meet one-on-one or if you meet with anyone here, um, we'll probe a little bit more to find out, number one, which country you're immigrating from and what's going on with that country and what's going on with policies here in the US impacting that country. Um, and we would probably tell you that if you make the decision anyway, since you're a grown up and it's always your decision, if you make the decision anyway to pursue that tourist visa, you've got to be careful that it is consistent with whatever information you have already shared with the government through that immediate relative filing process that you have there. But speak one-on-one with an attorney about some of those dynamics, okay? Let's go. Freedom Now, guys. Thank you so much for being here today. Um, where are you located? Do you do habeas cases? We're located in White Plains, New York, and yes, we do habeas cases. Um, Do I have any idea why they send work permits to asylum people, but not to people who have a current I-130 petition? The policy rationale. So, I, asylum seekers have various rights as they're going through the immigration process. A lot of rules govern them and their and work permit and their process, and there's just a lot of protection that is offered to people who are seeking protection here in the United States. The I-130 process, I don't know what the rationale is, really, the policy rationale behind that one, because you would think that if you have a family member here in the U.S. and you're here in the U.S. and you need to work because living in the U.S. is a very expensive lifestyle. So, but they have limited it, maybe because they want to not encourage people to come here and overstay and file for a green card. Maybe it's one of those types of rationale. But certainly, if you have an I-485 pending with that I-130, yes, you would be eligible for the work permit. Are you planning another round of the lawsuit? Yes, earlier I did announce that by Wednesday. I have to give my team some time to breathe and keep it pace really with me and all of my ideas. So it's by Wednesday. We're going to open up round two for the 39 country USCIS adjudication pause. So stay tuned, get on our email list to get that notification. Um, let's see. Um, do I know if detainees are safe in ICE custody? And have you visited any of their facilities? Um, what do you think about the U.S. citizen children that are being placed in foster care after parents are deported? Okay, three questions. I won't be able to answer all of them. I have not visited a facility in years. I will tell you that years, because a lot of my work is administrative and running this company. So I have not been to one of those facilities in years. Do I think they're safe? I think that based on what I see and hear from the other sources and even my own colleagues, um, it depends on where they are. It depends on which facility they're in, because the facilities, as you guys know from videos and not videos, but just from reading broadly, things are horrible, 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 horrible. And even stories that we hear, and even some of our own clients in detention, the conditions, it's awful, the problems that they're suffering from. So for some people, it is really, really, really not a safe environment, particularly if you have underlying health needs and illnesses. It is not the place for you. Any of those centers or detention centers or camps or whatever you want to call them, they're just not a good place to be. And unfortunately, under this administration, it's even worse than before. The one that I did visit, the most recent one that I visited years ago, I didn't get a chance to really go into the back and see things, but it was pretty decent. It was pretty decent. Our client at that time didn't really have any health concerns, but nowadays it's more of a health concern being in there because of the conditions that they face. Um, okay. And then with regard to parents turning their children over to the foster care system, or children being turned over, I should say, to the foster care system, I can't even weigh in on that issue. Um, um, what was the first round of our USCIS adjudication pause successful? Someone is asking on TikTok. We did receive a major temporary win that other people around, attorneys around the country have been talking about. I'll share more with our plaintiffs tomorrow. We still have a ways to go. to see the pause lifted. The litigation has recently just started, really, and so litigation is a process, and it could be highly unpredictable. But yes, we have seen we have the judge issued a stay in the Boston case, but I will share more tomorrow to the plaintiffs in terms of what it means and what's next for us. What our strategy is, and what they could expect and how we're thinking about things. So they will get that insight tomorrow night at 8 o'clock p.m. All right. Thank you, guys. I don't know anything about British law. Um, Does the travel ban apply to advance parole? So if you're here in the United States and you've been granted advance parole and you're from one of those 39 countries that are either fully restricted or partially restricted, I don't think you should travel. You should not travel. You should not leave the United States at all, not even on advance parole. Okay, thank you. Freedom now, guys. If a person has an EAD, an employment authorization document, or a work permit with a pending I-360 and I-131 advance parole and an I-485 and meets ICE, what will the person do? When you say meet ICE, are you talking about, is this person checking in with ICE or just happen to maybe be detained by ICE? I don't see how you would be checking in anyway with ICE if you have the I-485 pending. But in any event, let's say what you mean is that if they are detained somehow by ICE, well, first of all, um, a lawyer should be hired if that person doesn't have one. If that person doesn't have a lawyer, they could assert their own rights and not sign anything. And they will be placed in removal proceedings and go before an immigration judge. And go before an immigration judge and bring their case to the judge. And with the I-360 pending, you could ask for dismissal or administrative closure. If the administrative closure will be granted. It's very challenging to get that today, but certainly speak with a lawyer about a strategy if you happen to meet ICE and you have all of these applications and petitions pending with USCIS. All right. Is it true that the pause on the asylum decision is lifted? What's true is that USCIS is now processing asylum applications for individuals who are not from one of those 39 countries that are currently facing the pause right now. Let's go. Freedom now. Thank you so much for being with me. Let's go down a little bit here. Um, let's see something here. My lease is 92 pages. How many pages should I upload to USCIS? You must be, I don't know, from a city like maybe New York City or maybe because that's a long lease. That is a long lease. Um, Use your discretion on that one. I don't know if it's necessarily important to upload all of those pages. So long as what's key here is that it's an authentic lease that was properly signed by the landlord. Um, uh, but if you could scan all of those pages, scan them and send them, that's your prerogative. I don't think it's going to really make or break things. But just so you know, really, it's better for the integrity of the document, of course, to send the entire thing, the complete document. I'm just kind of annoyed that they would even give you 92 pages for a lease. That's crazy. Okay. Let's see. What about spouse visa? I'm in Cameroon and my husband is a US citizen. So, as you know, Cameroon is facing the pause right now with regard to the immigrant visa process, I think, right? Okay, and that's it. But USCIS can adjudicate your spouse's I-130 for you. All right, so your spouse should still submit the I-130 and USCIS will adjudicate that. It's just that there's a pause currently on the issuing of immigrant visas for your country. Let's see. Okay. Um, can I sue USCIS if I requested military parole in place and now it's paused? That's a real strategic issue. You know, the thing is this. Military parole in place is discretionary. Of course, 485, the adjustment of status, also has its discretionary part that's connected to it. Um, you may have probably heard others say that, well, if you have a case like that has some degree of discretion, don't do a lawsuit, don't do a lawsuit. Um, I don't think you've heard me say it in that manner, and that's because, where our lawsuit is narrowly focused on that pause, lifting it so that you can get to that final adjudication, that final outcome based on the merit of whatever case you've put before USCIS. Um, but what I would also say, though, is that it's good. It might be a good idea to speak with an attorney one-on-one to really unpack a little bit more on your background before joining the lawsuit. Um, Not sure about that. And by the way, as I mentioned, if you're a plaintiff in the 39 country lawsuit, join tomorrow night's meeting. I'll be answering your questions there. So I'm not going to take those questions during this forum, okay? Other than, obviously I've already shared what I needed to share publicly, and everything else just I'm holding on to until tomorrow night. So be sure to register for tomorrow's meeting, Zoom meeting. Okay. Is there any update with regard to the Dignity Act currently in Congress? I have not seen any update regarding the Dignity Act. Someone had a question about a master calendar hearing. It's gone. Is it okay? Let's not. What can I expect at my Stokes interview? Someone is asking. You could expect to immediately be separated. They're going to pull, usually it's the petitioner. Petitioner would likely to be the one to go in first and be questioned. And then the immigrant will also be questioned at length. They could ask you up to 100 questions. And I know because I've been in them. They could ask you up to 100 questions, and they're going to pull you both back in together. And if there were any inconsistencies, they're supposed to give you an opportunity to clear things up. And it's great to have a lawyer with you because that lawyer will be able to sit in on your meeting, your interview, and your spouse's interview. And if the government tries to pull a fast one, the lawyer can, be there to help reconcile and help you clarify things on the record. So it's a very intense interview, usually very intense. So you really need to prepare very, very thoroughly for that Stokes interview. Very serious interview. So really, please prepare. Double tap the screen. Birthright citizenship is still pending before the U.S. Supreme Court. A decision is likely to come out in June. Someone asked a question on Instagram about if the birthright citizen decision goes the other way, whether they could lose their citizenship. And the answer is no. You cannot, you won't lose your citizenship based on this case that's pending before the U.S. Supreme Court. What is the maximum and minimum wait time for consulate interviews? I've waited 7 months so far. It really depends on the country and other circumstances. So I've seen some clients get their interview the following month after becoming documentarily qualified. And I've seen people wait 3 years sometimes, depending on what's going on. Like during COVID, of course, we saw the worst wait times even after COVID. Some of those embassies were still trying to get caught up, and it took a long time to get an interview schedule. Any news about the 75 countries visa pause? No, none. None today. Is Is there a hold on visas? We became documentarily eligible on February 20th, but had not gotten a date yet for the interview. So the hold or the pause on the immigrant visas will not impact, or it should not impact you getting your interview date. The embassy makes the decision about when they are free. They have time on the, space is available on their calendar for the interview. And once that happens, you'll be notified by the visa center of what your date is. So they are progressing people all the way to the end, all the way to an interview. So that pause will not and should not impact you getting a date. Okay. Um, The onboarding for us will begin by Wednesday of this week. We'll announce it on our email list for the 39 country lawsuits. It's been who's counting? Who's counting though, right? It's been 447 days since I've done my interview, but I still have not gotten any updates about my I-485 adjustment of status application. What's going on? They're doing background checks. Something is happening. For some people, it could be the fraud unit that's now involved in the case. That is an extraordinarily long and unfair time for you to be waiting. You could potentially file a mandamus, that lawsuit, force them to make that next move. You should definitely speak one-on-one with an attorney to see whether what's going on there. But that's very long since your interview. So when this person says that it's been those many days since interview, that tells me, based on experience, that the fraud unit is involved in your case. Um, that's what that tells me. And so you really need to get lawyered up, be lawyered up. Okay. Thank you, thank you, thank you, thank you. Um, I I filed my adjustment of status application in January. I did my biometrics in March. Now my interview is scheduled for May, and I have not even gotten a work permit yet. Should I be worried? No, I don't think you should be worried based on that. But what I'm so glad, Charmaine, that you asked this, you mentioned this because people don't always believe everything I say. So you just validated a little bit of what I've said in a video recently that they're moving fast, guys, with some of these cases, particularly on the marriage side. They're moving a little fast and scheduling interviews very quickly. So you've got to be prepared. You've got to submit a good, strong case with the expectation that you're likely to get an interview quicker than you expected. And so Charmaine has, I guess, confirmed that a little bit based on her experience there. But I don't think you should be worried. You should be prepared, though, you and your spouse, if it is a spousal case. Thank you, guys. I got a green card through marriage, but I do have a pending asylum application that was withdrawn. Can I travel back to my country? And I see that this person might be Jamaican based on the person's handle here. The government, you did withdraw it. Yes, okay, you withdrew it. But can it stop them down the road when you're seeking naturalization from probing a little bit about what made you go back to a country that you said that you were afraid to go back to? Because if you were to go back to it, you could be persecuted. They could do that. They could definitely ask some questions during naturalization. Coming back in, however, on your green card, you'll be fine at the airport, I think. But naturalization, I think you should speak with an attorney before you apply for naturalization down the road. Okay? Um, what's this all about? Are they issuing a renewal green card offer received approval letter? Issuing renewal green card. I'm not sure what you're talking about. Paulette, are you talking about the I-751 removal of conditions process? Um, I'm not sure what this means. Approval letter. I'm thrown off by that last phrase. Who's next? Thank you so much for being here today, friends. I have completed my asylum interview. I've completed my asylum interview. What is the next step after this interview? Are they going to place me in removal? Well, it depends on how well things went at that interview. If they are going to refer you into the removal system, you'll know about it. They'll send you that notice. Um, um, if they approve it, great, you'll get your approval letter. So it's one of either one, really. Is it possible that they could call you back in for a second interview? I've seen it happen for some people, but that's not very common. So I think really it's either a referral letter to the immigration court system, removal system, or it could be an approval that you'll receive. Hopefully, you're approved for the asylum. Okay, thank you guys. Again, thank you so much for being with us during our Friday webinar. It was a wonderful time. Stay tuned for the date of our next webinar, which I think will be about a marriage case. Let's see if one of my colleagues can confirm the topic of our next webinar. Okay, let's go. Tomorrow at 8 o'clock p.m., I will be meeting with the plaintiffs that are connected to our Boston case, 39 country USCIS case. What's happening with the I-90 applications? I haven't heard anything in particular other than things are slow with regard to the I-90 process, but I don't know what else could be going on. What's going on there? Thank you. Let's go down a little bit. My I-130 was approved in 2024, and I completed my I-485 interview 90 days ago. Okay. I haven't received any updates since then. Okay, 3 months ago, you were interviewed. Could this delay be related to the processing pause for Nigerian applicants? Maybe, yes, maybe. It could very well be. I mean, that there's that adjudication pause. It doesn't matter really where a person is in the process. They're not going to achieve that final adjudication. Now, the I-130 was approved in 2024, and then the 45 interview. I don't know how things went during your interview 3 months ago. How did it go? Because they might want more information from you through an RFE. You could speak with an attorney one-on-one if you are concerned about the fact that maybe it didn't go so well. But if it went really well and you're not worried about it, no need to really speak to an attorney right now. Again, the pause is in effect. You can consider joining the next round that we have. The topic for our next webinar is it is marriage-based green card strategies. However, strategies for those with a 2-year green card. We're going to be tackling the removal of conditions, process, and strategies in our next webinar. We'll get the date to you guys on who are on our email list, and we'll advertise also, of course, on social media once we select the date. It was actually supposed to happen last week. We're a little behind. It's all me. It was supposed to be last Friday, but we had to shuffle things around. Okay, double tap, double tap. Let's see. Thank you to all of the longtime watchers here on TikTok. The system here, the app is telling me who's a long time viewer. Thank you. Are they giving green cards based on marriage to people from Nigeria? They're not doing it at this time. No, they're not giving the green card. They're not printing and mailing the green card at this time for those who are from the 39 countries. Friends, again, we're reachable at McBean Law at 914-898-9488 to go one-on-one with an attorney. I'm not sure whether, I think we might even have, let's see if I could find out real quickly. If we have appointment slots this week. Okay, I've asked whether we have appointment slots, and if so, the earliest appointment, the earliest availability. Okay, let's see if I could get that answer to you before we go today. Again, we're reachable at 914-898-9488. And if you have an emergency matter, like you have a deadline to meet, like a RFE or NOID, annoyed, or your case was denied, you can get an emergency appointment with one of my colleagues, but you must say this during your phone call so that it could be escalated, and we would obviously take a look at that letter to ensure that we can meet your expectations. Okay. Thank you. Say something here. Are they processing naturalization applications for people from the banned countries? Someone is asking here on TikTok. They are, they're going through the process, of course, and then that's it. You're not going to get the final, which is what you need, decision and oath ceremony scheduled. Okay. So the earliest availability that I'm seeing here from one of my colleagues, I see that there's an April 16th appointment slot at 12:45 p.m. with one of my colleagues. 12:45 p.m. on April 16th. See something here. Okay. That's Thursday. So that's not too bad. Okay, let's go down a little bit. Is let's see, someone is asking whether Honduras one of the 39 countries? No, it is not. Honduras, there is no adjudication pause on the country of Honduras. Okay, let's see. There are other times available. Trying to get you guys some more information. Also, same day, April 16th, we also have a 1 o'clock, a 1:45, a 2:30, and a 3:15. Okay, so Thursday is a good day. It looks like Thursday is a good day. 2, 3, 4, 5 slots from what I see here. 5 slots on Thursday, April 16th. Okay, guys, we're going to wrap up now. Thank you so much for being with me today. Again, tomorrow at 8 o'clock p.m., we will have a live session with the plaintiffs in our 39 country USCIS adjudication pause lawsuit. Okay. So check your email to register, and we'll have time where we will answer your questions. But I will share what's going on and what we're thinking and what our strategy is, and answer your questions. So that's tomorrow. If you have not yet reached out to us, oh, it looks like we also have Friday availability too. Friday, we have 4 slots available, 10, 12, 2, and 3 o'clock. So this week, we have some slots available for consultations on Thursday and Friday. But if you have an emergency appointment, definitely tell my colleague on the phone that this is really an emergency based on the fact that you have a deadline to meet, and we will ask you to send us right away your letter so that we could confirm that, and then we will book that meeting with you. Thank you so much, friends, for being with me today. It was wonderful being with you. I almost forgot. I almost forgot the success story. Before we go, we had a terrific success story that we shared with you guys yesterday involving our client from Thailand who entered the United States on her K-1 fiance visa in 2003, but she did not marry her petitioner, the K-1 petitioner, and she stayed in the United States for many years. She's still here. Later on, she, of course, met someone new, another U.S. citizen, and they dated for about 5 years or so before they got married. And that was a bona fide relationship. And they got married. Eventually, they came to us and met with us. And we discussed the fact that she will need an I-130 petition. And we worked on that case and it was approved. Then we worked on the waiver, the I-601A waiver, because of the unlawful presence issues that are on her record and the fact that she has to consular process because she did not marry the original K-1 petitioner. So we filed, and so she has to go to a U.S. embassy ultimately to finish her case. So we filed her waiver, the I-601A waiver, that was filed in 2024, and it was approved in April of this year. So 2 years of processing on the I-601A, and the I-130 was approved in 2023, and now her case has gone over to the Visa Center for further processing, which after that processing, she will get a date for an embassy interview. But note that this is Thailand. Thailand is on the 75 country adjudication pause list. So by the time her case as her case progresses through the Visa Center, we will be monitoring what's going on with that pause. And if the pause is still in effect, obviously she will need to file a lawsuit or join a group lawsuit if we do another one for the 75 countries or the 52 countries, and so that she could have a fair chance at the U.S. Embassy for that visa. So friends, very exciting story. I'm happy for her with that waiver approval. If you have a waiver case, don't hesitate to reach out to us. We do all of the immigration waivers at McBean Law. Thanks so much for being with me in this one, guys. I will see you in the next one. Bye-bye.